Good evening. This is John Milburn for Laws 12063, Advanced Statutory Interpretation and Drafting. We're into week 10. This week we're dealing with ODGA's Chapter 15 primarily of Senate practice. This is an online material. This is material that you'll find online, and I do urge you to consider that, together with the Legislation Act 2003, which is Commonwealth legislation, the Commonwealth Office of Parliamentary Counsel Drafting Direction 3.8, which deals with subordinate instruments, and a very interesting article by Stephen Argument called the Legislative Instruments Act 2004. Is this the cherry on top of the legislative scrutiny cake? So we're going to deal with some of those tonight, but I urge you to read those privately. This material is not directly referable to your assessment, so it will be a short session tonight. I know I say that sometimes, but it will be. So let's make a start. The first place to read the material for this week, if you haven't already done so, is the study guide. Some excellent material there in terms of what we propose to do and some worked examples for you to consider. This week we're considering, I guess, fundamentally the difference between primary and delegated legislation. Primary legislation, of course, that which is made directly by Parliament, as opposed to delegated legislation, that which is made by members of the executive following a lawful delegation of power to it by Parliament. That's the primary distinction that we're making. And from that, we look at, this week, drafting delegated legislation. That is, ensuring that it's properly within the appropriate grant of power. When considering drafting delegated legislation, as with drafting primary legislation, we need to consider the role and extent of use of extrinsic materials. And extrinsic materials will typically accompany delegated legislation. And you'll find some material about this and some worked examples, and we'll look at that later this evening, on the Federal Register of Legislation. So some great resources there, and we'll show you that shortly. All right, so some basics. We're going back to Introduction to Law now. Separation of powers. We know that Parliament is the only body in our system that can create acts, but Parliament may delegate some of its lawmaking responsibility to public servants. And the power still belongs with Parliament. It's simply a delegation of the task. So from that, what can we glean? The first is that the public service can only make laws, statute laws, if Parliament expressly delegates those powers to do so. It follows that the public service, the executive, cannot under any circumstances make laws that go beyond the powers of the delegation. So it's fairly obvious, I guess, that if you're acting for a party that is adversely affected by a form of delegated legislation, the very first thing you do is to check to ensure that the delegated power was exercised correctly and lawfully, because there is always the opportunity to argue the contrary position, in which case your client would no longer be bound by that delegated legislation that is affecting adversely the client's interests. So that's the first thing. Secondly, the delegated legislation must be placed before Houses of Parliament, and Parliament may disallow the legislation. In other words, Parliament delegates the responsibility, however maintains a very real level of oversight and the ability, for want of a better term, to veto by exercising the power to disallow the legislation. However, once these rules have been followed, the delegated legislation has the same status as parliamentary or principal legislation. In other words, it's still binding in exactly the same way on citizens as if it were law made directly by Parliament. Any questions so far? All good? Well, I'll keep going. Please feel free to unmute your microphone. Use the chat facility if you have any questions as we go. So last week, the last few weeks, we've been talking about drafting techniques for primary legislation. The same techniques apply for the drafting of delegated legislation. Now, what you would have seen is that there are many types, many names given to forms of delegated legislation. The most important and the most popular, if I can use that term, is regulations. So if you're concentrating your reading, have a look at regulations in particular. But we're going to show you legislative instruments generally by reference to the Federal Register of Legislation as well. All right, so hopefully you've had a chance to read the material for this week. If not, please do so. Again, you'll see some key terms in your study guide. Delegated legislation, which is this broad term encompassing all sorts of delegated material, regulations, declarations, proclamations, and others. Ordinances, there's many. Disallowance, we know about that, the process where Parliament may, once something is presented to it, tabled, have an opportunity to disallow it or reject it. We know all about explanatory statements or explanatory notes as the reasoning behind the introduction of material. So in the context of delegated legislation, we refer to explanatory statements. Those of you who joined me last night would have seen that in the context of some work that we were doing in ADR. Extrinsic materials, I think we all know what that is, and the grant of power has two phases to it. The first is that which is granted, that which the executive can lawfully act upon, and the adverse of that, or the contrary position of that, is ultra vires, the Latin term that means above or outside the powers that are given. So if delegated legislation is ultra vires, it is by its very nature invalid. It goes beyond the grant of the power, so that's the argument that you primarily make if you're seeking to avoid the imposition of some liability as a result of delegated liability or responsibility. In the study guide, have a look at the example given about the Gold Coast bylaws. It's 1994 1 QDR, and the Queensland Supreme Court considered a bylaw. It was a piece of delegated legislation. The council said you can't sell goods on a road or land adjoining a road under the control of a council without a permit. Fairly straightforward, you would think. The bylaw was made under powers granted under the Local Government Act, which gave council ability to make laws in its opinion necessary or conducive to the good rule and government of the area and the well-being of its inhabitants. But did that bylaw go beyond the power that was conferred upon the council under the Local Government Act? And the court found it did. Justice Thomas said, the coverage of this bylaw is astonishingly wide. The activities prohibited would include the carriage of goods, driving of taxis, conducting of shops, banking activities, and all sorts of commercial arrangements, including those conducted by telephone. And that's simply not within the bounds of the law that was delegated to the council. So the bylaw was far too reaching, far too wide in its ambit. So that's the sort of argument that you want to look at. And you can see how, practically speaking, you can run that type of argument. Now you may have to go to a couple of different courts. So for example, I've had instances where we've argued something in the magistrate's court following a prosecution of, say, Commonwealth legislation. We've argued that the rules that led to that situation were invalid, so we have to go to the Administrative Appeals Tribunal, for example, to argue some of the preliminary matters that ultimately led to the imposition of the criminal charges. Anyway, I'm going off topic a bit. In your study guide, you'll see that there are 3 steps that you need to consider in this field. Number 1, what's the purpose of the grant of power? So again, we look at the purpose. The purposive test is relevant. So what is intended by the conferring of the power, which is, once you've answered that, it's much easier to determine, of course, whether the power actually made or the way in which the power was exercised is ultra vires. In the study guide, look at Community Services Aborigines Act 1984. The powers intended self-government for Aboriginal communities, and the Governor in Council, it said, could make regulations not inconsistent with the Act, but the power potentially was extremely wide-ranging. And in the study guide, it talks about a hypothetical scenario. What if the Governor in Council had created situations that effectively were tantamount to native title legislation, so going well beyond the power. So number 2, yes, Helen, do you have a question?
Oh, I do, John. Sorry. Is this a kind of, you stepped back and took a broader view? Is it to do with is it a question of constitutional invalidity as well? You know, the cross-vesting scheme with the courts and the case of Joaquim, they found that was it the state courts, they tried to invest it with power from the federal court, or is this a bit more specific about?
It's more specific.
Yeah, okay.
It's akin to that principle of being ultra vires, but it's more in the context of not a dispute between federal and state parliaments, which is more the constitutional realm. What we're talking about here, although we're talking about it primarily within the Commonwealth ambit, it applies in the state ambit as well, is the ability of the federal parliament to delegate to the executive, to the public service, the ability to make laws. So it's not, if you like, Commonwealth versus state. It's, if you like, Commonwealth Parliament versus Commonwealth Executive, Commonwealth Public Service. So in making delegated legislation, the executive can only go up to but not over the powers conferred upon it under that delegation. I hope that makes sense. But in both contexts, you're perfectly entitled to use the term ultra vires. So there is that conceptual double up. Thank you, Helen. So the second is, what are the limits on that grant of power? And the third, are there any preconditions required to be met in order to create that delegated legislation, regulation typically? In your study guide, you'll see the drafting process. 4 steps. Number 1, follow the established process. Number 2, refer to the principal provision. Always do that. Say this delegated legislation is made based on power conferred to the delegated, the authority by Parliament pursuant to this Act. Number 3, the focus should be on practicality. And number 4, ensure the regulation remains within the powers. So that's what you need to do from a practical drafting perspective. Now let's look at the Legislation Act 2003 Commonwealth. If you have access to the Federal Register of Legislation, please do so. I think you probably won't find it in AUSTLI. Sometimes AUSTLI won't contain everything. It might be there, but I think it's better to go to the Federal Register of Legislation in any event. So what I want you to do is particularly look at sections 8, which defines, if you like, the power, defines a legislative instrument that we'll look at shortly, what is made in the exercise of that power delegated by Parliament, and have a look at sections 15A through to J, which effectively establish the Federal Register of Legislation and requires that legislative instruments be registered, which is section 15H. We'll look at that shortly. provides that no legislative instrument can be enforceable until it's registered, provides for provision of explanatory statements to accompany each instrument, and encourages rulemakers to undertake appropriate consultation and report on that consultation in the explanatory statement. In other words, the Legislation Act Commonwealth sets the parameters about the mechanics and provides a registry for these legislative instruments and provides rules in relation to how they become enforceable, because they've got to be known, so therefore they've got to go onto the Federal Register of Legislation, and there needs to be some sort of explanation. These laws that are made under delegated legislation can't just appear without any explanation as to what they mean. So hence the requirement for an explanatory statement to accompany them in the same sort of way that we see for legislation. Now, if you have read the article by Stephen Argument, then you'll see that there's some background to the introduction of the Legislation Act. And I'll just refer you to parts of the introduction. I'll just read it briefly to you. So Stephen Argument worked with Professor Pearce from your textbook in assisting in creating this legislation. So in the introduction, Stephen Argument says, the single most significant element of the Legislative Instruments Act is its application to all instruments made in exercise of a power delegated by Parliament that are of a legislative character. Section 5 of the Act provides that an instrument is of legislative character if A, it determines the law or alters the content of a law rather than applying the law in a particular case, and B, it has a direct or indirect effect of affecting a privilege or interest, imposing an obligation, creating a right, or varying or removing an obligation or right. So when we talk about legislative instruments having a legislative character, it's more that general application that we see in legislation rather than an executive decision that relates to an individual circumstance or an individual case. Now, Stephen Argument goes on to say, why is this significant? The significance of the definition is that unlike other jurisdictions, the regime provided for by the Act operates by reference to what an instrument does rather than what it's called. Now, this follows on, as an aside, this follows on from the fact that the Commonwealth was a little late in bringing into legislation the Legislative Instruments Act. So other jurisdictions in Queensland, states and territories had actually got a jump on the Commonwealth. And when you read Stephen Argument's article, there's quite a bit of angst about that fact, that the Commonwealth was not first to create this situation. However, Stephen Argument does provide for a point of differentiation between the Commonwealth regime and other Australian jurisdictions, and says that in other jurisdictions of Australia, whether or not an instrument is subject to the relevant regime for publication, tabling and disallowance is governed by whether or not the instrument is referred to in a certain way, depending on the jurisdiction. So what he was saying in that article is that the effect of the approach to instruments at the Commonwealth level is that they're all required to be dealt with in a certain way, and the regime works on the basis of what they are do rather than what they're necessarily called, as is the case in other jurisdictions. So have a look at that article to get just a background to the Act. So let's have a look at the Act now. For me, I'll share the screen and I'll take you back to the starting point. So the Federal Register of Legislation, you should see that on your screen now. I hope that that landing page is very familiar to you, and you'll see that there are two links to legislative instruments in force. On the side column, Acts, legislative instruments, etc. or by the blue tiles. Top right-hand corner, the dark blue tile, legislative instruments in force. So let's just have a look at what that is. And it's laid out in a similar way to Acts of Parliament. Let's take one as an example, EN, which should take us to environmental law matters. And you'll see here, for example, the third one down is a legislative instrument made pursuant to the Environment Protection and Biodiversity Conservation Act 1999. And you'll see that that instrument, that particular instrument, the third one, relates to blue whales. And if you look at the series, you can download it, of course, or you can look to the series and you'll see the link to the principal item that led to it, and that's the Minister for Environment indicating on the 28th of September 2015 that pursuant to Section 269A of the EPBCA, the Commonwealth has allowed a recovery plan in relation to the conservation management of blue whales to be prepared, which has led to the instrument making the recovery plan. So I'll leave you to look at that for yourself. Just have a look at different instruments, get a feel for the way they're made, and you'll see that there's reference there to the authorising act that led to the creation of the instrument. It's not a regulation per se, but it is part of the delegated legislation regime. Now, have a look at ODGARS, Chapter 15. This is Senate practice. It starts at page 429, and if you pan down 10 pages to page 439, you'll see a table or a flowchart, which is always very useful in providing background as to these circumstances. And just in case you haven't yet found it, I'll share the screen, expand the table so it's a little easier to read, and I'll do that now. So that figure 1 is an extract from ODGARS, Chapter 15. It's on page 439. Sorry for moving it. Just trying to make it a little bigger. I'll just expand it that way. And you can see that the figure relates to the scrutiny of delegated legislation in relation to the Senate and provides a flowchart as to the process, noting at the bottom the issue of the potential for disallowance by the Senate. Now, the making of delegated legislation is something which is different to the process of making primary legislation, for example, in that there are no stages for the legislative passage or the opportunity for amendment, as we see with primary legislation. There are some prohibitions, there are some general rules. For example, there's a prohibition on retrospectivity of delegated legislation, where the rights of a person are affected to disadvantage that person or where liabilities are imposed on a person. So in that regard, when it comes to the rules, look at the Commonwealth Office of the Parliamentary Council drafting directions, in particular 3.8. Again, I'll share the screen. You should be able to find these. If you don't, please let me know and I can access them, provide them to you, or upload them to Moodle. But one of the reasons and I may have provided this already, but I do like you to be able to find these things because that's part of the process. You'll see in the drafting direction 3.8, which relates to subordinate legislation. Part 2, power to make subordinate legislation. Part 3, commentary in relation to the Legislation Act. Now, in terms of the use of legislative instruments, which is on page 3. Hyperlink's not really working very well, so I'll just pan down to it. You'll see that the paragraphs 2 and 3 are important because they set the scene. So the OPC starting point in relation to subordinate instruments should be to make them in the form of legislative instruments as distinct from regulations unless there's good reason not to do so. Drafters should mention to instructors, etc. And then it goes on in paragraph 3 to say material covering certain things should be included in regulations unless there's some strong justification for prescribing those provisions in another type of legislative instrument. So regulations are a form of legislative instrument, but the documents that I've shown you in the Federal Register of Legislation are those that are registered instruments, which are formally set out in the Federal Register of Legislation. All right, that's all I propose to deal with tonight. Do you have any questions? All good? Yes, Helen?
Sorry, I can't seem to get that link for Odgers on the Moodle to work, but it might just be me.
Hey, John, you're muted.
No, my apologies. Sorry. Yeah, sometimes the links don't work because of sensitivity for my SharePoint. But let me just see if I've got the...
Just because I was just looking on the legislation site now, when I put in Odgers, a whole bunch of stuff comes up. So I can find it on my own, but I didn't know if it was a particular... Is there a particular publication?
Mm-hmm.
Then I'll just look in that on my own. So it should be accessible on the federal website for everyone, or
no, on the OPC website.
OPC. Okay,
yep.
That's cool.
And
I can find that.
What you'd need to look out for is Commonwealth Odgers Australian Senate Practice.
Yeah.
2016.
Okay, thank you.
I think you'll find that on OPC.
Yeah, no worries. Thank you.
All right. Okay, so I hope you're all progressing well with your second part of the assessment. I think that's due in about 2 weeks. And then we have the third part of the assessment, which requires you to send to me a document with the way in which you've contributed. So if you've attended sessions live, please make a note of it. Or if you've viewed sessions at a later time, just make a note to that as well, to that effect as well. All good? Okay, so nice short night tonight, and we'll see you next week. All the best. Bye.